Good morning, everyone. Jackie Broman here for Legally Join Jackie on Mondays at 10. So today I'm going to be talking about who can make a claim against a will. Now, there's two different ways you can claim on a will. The first is an outright provision claim where someone wants more from the will than they got. And the other is claiming that the will is invalid. So they're the two types of ways a will can be challenged. Now, I'm not focusing on the challenge of a will's validity today. I'm focusing on someone challenging a will because they want further provision from the will. Now, who can do that and what's the process? Now, it used to be open slather in Victoria more than any other state. And so that's why there might be lots of horror stories out there. People will have heard people making claims on wills, getting big payouts, things like that. But this all tightened up in about 2015. So now Victoria has one of the tighter laws in Australia around this. And to make a claim on a will, a person has to be in a specific category. So previously it was open slather. It could have been someone down the street who helped with the shopping. It could have been a carer. It could have been someone who'd only been on the scene for the last 12 months. But now, no. Got to fit into certain categories. So what are those categories? Well, broadly, a spouse, a de facto, a child, a stepchild, or someone who's financially dependent. So those broadly are the categories. And if someone doesn't fit into those, then no, they're not eligible to make a claim. If you want more detail, of course, we can go through the legislation with you specifically, but that's generally where people sit. So it's no longer brothers and sisters can't claim, nephews and nieces can't claim. So you can rest assured that none of those people, just by helping you out or by being more in your life, that they're trying to insert themselves to get some kind of entitlement. No. Now, even though someone is an eligible person, it doesn't mean that they're necessarily going to have a successful claim, does it? So that's the other thing that we need to assess. We need to work out what is the quantum or the amount that they could get if they made a further provision claim. A further provision claim is not about punishing someone else who is in the will. It's not about changing the will. It's about this specific person saying, I was either left out or I haven't been sufficiently provided for. And so then they have to prove that they should be provided for. Just because they're in an eligible category doesn't automatically mean that they need further provision. So some of the things which are looked at are actually the will maker's wishes. So this is part of the problem with this area, is that the person who can defend the claim is now passed away. So we ask for people as much as possible to give evidence in the form of a letter for their reasons of leaving someone out if they're doing that. So your reasons are really important. The nature of the relationship. So if someone's estranged, why do they think that they can come back 20 years after the fact and have something from your will? If they are estranged, how did that come about and who maintained the estrangement? Sometimes that's a factor. The person who's making a claim, their own financial situation is also relevant, as is the financial situation of beneficiaries who have been provided for. So a will maker has to weigh up their obligations, and if they leave an adult child out because that adult child has been provided for, they've been given some money during their life, they're doing well financially, they have a house, all the things, a parent doesn't have to, there's no further obligation to look after an adult child. So adult children are the ones who tend to think that they have some kind of entitlement, but No, in fact, you're not entitled to have a house paid off by your parents. So yeah, quantum is assessed based on a whole lot of factors, and I've just rattled off a few of those which are relevant. Another relevant factor is also the future need of someone. So if someone was quite unhealthy, or they were supporting disabled children of their own and their needs were greater and they didn't have much earning capacity, then that might factor in as well to having further provision. But on the flip side, if someone's so unwell that their longevity of their life is actually predicted to be fairly short, then that might counteract the argument about further provision, because in fact, well, you don't actually need that much because you're not going to live that long. So there you go. It's not open slather on wills in Victoria anymore. It's actually quite tightened up. Able-bodied adult children are not doing all that well out of claims at all. Adult children who are left out, who are disabled or needy, drug and alcohol affected, do often do fairly well. Spouses, if a spouse is left out of the will, the law says, or the precedent over time has said that someone needs to provide a house and a nest egg for their spouse. The argument then is quite interesting about whether someone is a de facto or not, how they get across that threshold, and then if it's only a fairly new de facto relationship, how much of an obligation did the person have to maintain that person. So there you go. That's a little bit of an overview, so I hope that's helpful. Now, I do join Jackie on Mondays at 10 every week. The video while live gets saved onto the page, so there are hundreds of videos there that you can go back and have a look at. It's a good place to start. So if yourself or anyone you know has any initial legal questions they're just not sure about, this is a great resource to come to. You can share the videos with people via Messenger or commenting and tagging their name in the comments. Otherwise, I'll see you next week. If you do have any questions, please reach out. But I hope you have a great week.